I'm an immigration attorney currently in private practice, formerly an immigration attorney with the U.S. government. I'm pleased to be a part of this collaboration project with the Joseph Project. And thank you for joining us today as we discuss some of the immigration options available for survivors of human trafficking. I know that many of our providers do not have extensive experience or otherwise practice immigration law, so I want to give a very brief overview of some of the immigration statuses in the United States. The highest form of immigration status someone can have is U.S. citizenship. Next is as an immigrant, someone who has lawful permanent resident status, known as an LPR. This is where people have what's traditionally called a green card that allows them to live and work in the United States as well as travel internationally without exception. Next, there is a non-immigrant status, which is for people with certain non-immigrant visas, like a visitor's visa, tourist visa, student visas, things like that, where they're allowed to enter the United States for a specified reason, for a specified amount of time. And then it's expected that they will then leave the United States and return to their country of origin. Next, there is what's called temporary status in the United States. This is the category where things such as DACA, Deferred Action for Childhood Arrivals, and TPS, or Temporary Protected Status, falls into this category. And asylum is technically a temporary status. Next, there's something called parole, which is a form of permission to be in the United States, but it's not technically an admission into the United States. It's a nuanced area of law. And finally, the lowest level of status is someone who has no status. Maybe they entered the United States without permission, or they entered with permission but have overstayed their visa or violated their visa in some way. The first thing that we want to do as immigration practitioners is to identify what our clients' needs and goals are. We really want to have a survivor-centered approach that allows our clients to reestablish control over their lives and their situation. We want to work with them on identifying what needs do they have, what are their goals for immigration status. If someone needs a roof over their head or needs food for their children, they're not really going to be focused on immigration options or prosecution of criminals. They're focused on meeting their basic needs. So we want to identify what our clients' needs are. And we also want to figure out how we can work in collaboration with other providers to meet those needs. Some of our clients may need social services. Some of them may need housing or food assistance. Some of them may be okay in that regard, but they really want work authorization so that they can work and have their own income and control their own financial situation. So identifying what their needs are and what their immigration goals are is crucial as the first step in moving forward representing survivors of human trafficking. You also want to identify if their goal is to remain in the United States for a short period of time, or if their goal is to remain here permanently. Next, you want to determine your client's immigration status and their immigration history. So how do we do that? Well, start with the client interview, spending some time talking to the client, asking specific questions. How did you come to the United States? Did you have a passport? Which passport did you have? Do you have a copy of it? Things like that that help you really get a picture of their immigration history, their current status will help. You also want to review any documents that they have, both identity documents as well as immigration documents. Some people have had other interactions with U.S. immigration in the past. And so if you have any type of documentation, it's crucial that you review that to really get a clear picture on where your client has been in their immigration path and where you want to go forward and what options are available. And finally, you may want to pursue requests under the Freedom of Information Act or FOIA requests Keeping in mind, though, that there's not one immigration agency that's going to be able to give you a complete picture. You may need to do several FOIA requests with different government agencies in order to get a clear, complete picture of their immigration history, such as CBP or Border Patrol records. Any type of immigration enforcement records would be through ICE. If they've had any kind of interaction with the immigration courts, that FOIA request would go to EOIR, which stands for Executive Office of Immigration Review. And then finally, if they've ever filed an application here in the United States, it's likely that that went to USCIS, and filing a Freedom of Information Act with them may assist you as well. If your client is a United States citizen or a lawful permanent resident, there may not be much that you should or need to do in order to help them. You may assist in getting a certification letter or make sure that they have a certification letter that would help with immediate benefits for them. But other than that, as I mentioned before, citizens and residents have the ability to live and work and travel freely in the United States. So an immigration option for something else isn't really going to help them in any way. If you have a client that holds non-immigrant status or some kind of temporary status, sure, they already have some kind of status in the United States, but it may be that we can offer them something else. So you want to explore if there is another pathway that will broaden the options available to them. And if your client holds no status or is here on parole, it's very likely you'll need to pursue some other kind of immigration relief for them. If your client is currently in removal proceedings or in immigration court, or if they have been in immigration removal proceedings before, it's really important that you consult with a specific immigration lawyer, because there's some overlap and some intricacies that you want to make sure you're addressing correctly if the immigration court has jurisdiction over your client's immigration case. So once you've determined your client's goals and immigration history, that's when you can start to determine what is the correct immigration pathway forward for them. You really want to avoid forcing outcomes. And what I mean when I say that is we know that there is a visa specifically for survivors of human trafficking that's called a T visa. But you want to be careful that you don't just pigeonhole every trafficking client into pursuing a T visa, because that may or may not be the best option for them. Or it may be that you apply for a T visa in addition to some other form of relief as well. So again, the goal is to work to achieve the client's goals and to meet the client's needs. So we're going to focus primarily today on the most common forms of immigration relief for survivors of trafficking. It is not the only forms of relief, but it is the most common forms, and these are for people who are present in the United States. So the most common forms of immigration relief for trafficking survivors is continued presence, the T visa, which is the specific visa for survivors of trafficking, the U visa, which is for victims of certain specified crimes. There's relief under VAWA, which is based on domestic violence or abuse when there is a qualifying relationship. And finally, I'll discuss asylum options today for people who are fleeing persecution or are afraid of persecution in their home country should they return. So continued presence, what is it? It's specifically identified by law enforcement. It's unique in that it is requested by law enforcement. This isn't something that your client or you file an application for. Law enforcement at state, local, federal levels specifically request a continued presence status for or on behalf of your client. This is a temporary status that's generally granted for 2 years but can be renewed. Social services and work authorization are available for those with continued presence, but this does not lead to a permanent immigration status in the United States. For continued presence, the eligibility is identified by law enforcement. They're a victim of a severe form of trafficking in persons, and they may be a potential witness to a crime. Next, the T visa. This is the visa that Congress has specifically designated for survivors of human trafficking. This is a non-immigrant visa, generally granted for 4 years. It can be extended past that 4 years, but it's tricky and a little bit difficult. There are 5,000 of these visas that Congress has allotted every year, and that cap has never been reached. So they're generally available if your client qualifies. This type of visa does have a pathway to LPR status or permanent resident status in the United States after 3 years, which means that once your client is granted a T visa, 3 years later, they can apply to get a green card in the United States. There are social services and work authorization that's available for T visa holders. And this is an application requested directly by the client. So you would work with your client in completing an application and submitting it to the government, to USCIS, in order to obtain this kind of status. A T visa does allow for certain family members to be included in this application. It's important to know the age of your client in order to determine which family members may be included on their application. T visa eligibility is for people who have been a victim of a severe form of human trafficking. They must be physically present in the United States or U.S. territories on account of the trafficking. They must have complied with reasonable requests by law enforcement to assist in the investigation or prosecution of human trafficking or qualify for some type of exemption based on age or disability. And they must show that they would suffer extreme hardship involving unusual and severe harm if they were removed from the United States. And they must also show that they are generally admissible to the United States or that a waiver is applicable or available to them. Next is a U visa. A U visa is a non-immigrant visa for victims of certain specified crimes. It is not for victims of any crime, but it is for certain specified crimes that are detailed in the INA. There are a maximum amount of 10,000 of these visas that can be granted every year, and that limit is always reached, which means there's currently a backlog of obtaining a U visa. Once that cap is reached, if the government determines that your client has met the eligibility requirements, they just can't give you the visa because they've run out, they put them on a waiting list and are given something called deferred action or parole in the interim until the U visa becomes available for them. So they can wait in the United States during the pendency of the application from the time that it's filed to the time that it's granted, which could be 4, 5, 6 years. But once that U visa is granted, it's granted for a 4-year period of time. It can be extended, but again, this also leads to a path towards lawful permanent residency. Once a U visa is granted, the applicant can 3 years later file for their own green card. Social services are available to recipients of a U visa if the qualifying crime relates to human trafficking. It does not apply to everyone with a U visa. But social services can be available if the qualifying crime relates to human trafficking. Work authorization is available, but only after the U visa is granted. And again, that could take a long time. So identifying your client's needs may mean that some other form of relief should be pursued at the same time. Now, a U visa is an application filed by the client, and it does go straight to the government. It's filed by you in conjunction with your client. But the thing with a U visa is that it does require law enforcement certification. And what that means is there is a form that law enforcement must sign that endorses your client's application with the government. And you're generally applying to the law enforcement agency where the crime is being investigated or prosecuted. and you're asking the law enforcement agency to certify that your client is compliant, working with them, and has information or will have information that will assist them in the investigation or prosecution. Once law enforcement signs their form, then you are eligible to file for the U visa. The U visa does allow for family members to be included, but again, you need to know how old your client is, as which family members can be included depends on whether your client is 21 years of age and older or if they're under 21. For U visa eligibility, you must show that your client is a victim of a certain qualifying criminal activity, and I do have a list that we'll go over in a second. You need to show that they have suffered substantial physical or mental abuse as a result of the criminal activity. You must show that they have information about the criminal activity that's being prosecuted or investigated, that they have been helpful, that they're currently being helpful, or that they are likely to be helpful to law enforcement in the investigation or prosecution of the crime. You'll need to show that the crime occurred in the United States or that it violates a U.S. law. And finally, you'll need to show that your client is generally admissible to the United States or that there is a waiver. You'll see on this slide a list of some of the U visa crimes specified in the INA. You'll see, abduction, kidnapping, false imprisonment, things like that that are commonly used against survivors of human trafficking. So make sure that when you're coordinating with law enforcement, that anything that's on this list is also being considered by law enforcement. You want to include anything that may be on this list on your application. I want to note that felonious assault is included here, but not general or simple assault. So see your state's statute, your criminal code, and see how it relates to the federal definition of felonious assault to make sure that your client qualifies. And it may be that your state and the federal statute are close enough or maybe different enough that your client may qualify. So make sure you're able to do that. But what this U visa list includes is all of the forms of trafficking listed in the TVPRA, specifically involuntary servitude, peonage, slave trade, and trafficking. The next thing I want to talk about is relief under VAWA, or the Violence Against Women Act, which we know also applies to men, women, and children. This is a special immigrant status, which means it's a permanent status that leads to a green card. Social services are available once you meet an initial threshold determination, which is called a prima facie determination. Work authorization is available only after it's granted, not while it's pending. It's important to note this because this is another one of those applications that can be pending for years. This is an application filed directly by the client, not law enforcement. And this does allow for family members to be included on the application. Now, for eligibility under VAWA, you need to be able to show that your client has or has had a qualifying relationship with someone who is a United States citizen or a lawful permanent resident. The qualifying relationship has to be a spouse, parent, or child. So what you need to show is that your client's spouse, parent, or child is a United States citizen or lawful permanent resident, and that person is their abuser. You also need to show that your client has lived with the abuser at the same residence for at least some period of time, even brief. You need to show that your client is a person of good moral character, which is legally defined in the INA. So you'll want to make sure that you become familiar with the immigration definition of good moral character. You need to show that your client has been a victim of battery or extreme cruelty. And it's important to note that physical assault is not required. It could fall under battery, but what this extreme cruelty option does is broadens the definition of abuse, which is important in some of our cases. And finally, this application must be filed either while your client still has that qualifying relationship or within 2 years of that qualifying relationship ending. Finally, I want to talk about asylum. What is it? Asylum is, it's technically a temporary status, but it's issued for an indefinite period of time, which means when the government issues it, they don't give you a end date or termination date. But asylum can be terminated. But the good news is that if you have asylum granted, 1 year later, your client is eligible to file for a green card. Social services are available for those who are granted asylum status, and work authorization is also available just 6 months after you file the application and it's properly received by the government. This is an application filed directly by the client, either with the government agency that has jurisdiction over their specific immigration case. And it does allow for spouses and unmarried under 21 children to be included on this application. Asylum generally needs to be filed within 1 year of arrival in the United States or within 1 year of the circumstance that is the cause for the asylum application. Asylum is someone who has experienced past persecution or someone who has a well-founded fear of future persecution, and that persecution must be directly related or on account of one of 5 specified grounds, which is race, religion, nationality, membership in a particular social group, or political opinion. Also, protection under the Convention Against Torture is requested under the same application as asylum. Some final thoughts as you work to assist survivors of human trafficking is to maintain that survivor-centered approach. It is crucial that we are helping them regain control over their lives, their situation, their immigration status, and that we're doing that with their goals, their needs, at the focal point of how we litigate and navigate and advocate for them. And also to keep in mind that there are certain time requirements in immigration filings. So whenever you are pursuing immigration relief, make sure that you are filing those timely. And finally, be patient. Immigration law and advocacy for certain forms of relief can oftentimes take years to achieve. So be prepared for that, prepare your client for that, and make sure that everyone's expectations are in sync every step of the way. Thank you so much for joining me today. Thank you to the Joseph Project for putting this on. I want to thank you for your commitment to assisting survivors of trafficking, and I wish you all the best.